A Kentucky landlord is suing over a domestic violence law that allows the tenant to break the lease if they are a victim of domestic violence. But is the landlord wrong for fighting this law? I'm Tony, and this is Real Estate Investing and Landlord News. Alright, so I have an interesting topic to cover today, and it has to do with a domestic violence law that they have in the state of Kentucky. So basically what this law says is that if a person, is a victim of domestic violence, then they're allowed to go up to their landlord and break their lease if necessary. And that way, even if they have a 1-year lease term, they can get out of their lease and hopefully get out of that domestic violence situation. Now, this law, it looks good on paper. It looks really good. Unfortunately, the way that the law was implemented in the state of Kentucky was not correct, in my opinion, okay? And it's going to end up being a nightmare and a disaster, and that's exactly why the landlords are fighting it, okay? It's taken away their ability to do their business in the way that they deem correct, and it's not actually going to protect the person who is a victim of domestic violence. Instead, what it does is it allows a person who is within a contract to use the domestic violence excuse to break their lease. And that's not the way the law should have been implemented. So yeah, it's a tricky situation, and I agree with the intentions of the law, but the way that it's implemented, it needs to be rewritten, and I think that's what the landlords are hoping they're going to get when they sue the state. Okay. So before I get into the article, go ahead, hit the like, subscribe button, maybe leave a comment down below. Let me know what you think, okay? What do you think of a law that allows a tenant to break the lease if they are involved in a domestic violence situation? Okay, I personally think that it's a good idea. It's a good thing. If a tenant came to me personally, one of my tenants, and said, hey, my partner, they are beating me, and I need to get out of here because I don't feel safe here, I would have no problem with that, okay? It's an understandable thing. But, the situation in this story, that isn't exactly what happened. So let's get into the article, and I can explain exactly why, this law isn't working the way it was intended. So this article is coming from Kentucky.com, which is the Lexington Herald Leader, and it says, Lexington landlord forced domestic violence victim to pay rent after she fled, lawsuit claims. Let's get into it. The Lexington Fayette Human Rights Commission is suing Anderson Campus Rentals, alleging they forced a woman to continue to pay rent after fleeing her apartment due to domestic violence in violation of a 2017 state law. As part of its defense, Anderson Campus Rentals, which is part of Anderson Communities, is alleging the 2017 state law that gives protections to tenants involved in domestic violence situations is unconstitutional. Anderson Communities is one of Lexington's largest rental property owners and has multiple rental properties near the University of Kentucky. The case could have ramifications for domestic violence victims across the state, housing advocates say. When you read the first few paragraphs, this looks like, oh man, this is just a greedy landlord. They're trying to, squeeze money out of this tenant, and this tenant was a poor victim. And I'm not saying that the tenant wasn't a victim, right? What I am saying is that this law is poorly written, and because it's poorly written, the way that everything fell into place in this specific case, it's a disaster, okay? And maybe it is unconstitutional. Anderson Campus Rental Properties is making efforts to undo the recent bipartisan domestic violence protections. If they are successful, it would create a situation where victims of domestic violence would be stuck in their lease and left in a place that could put their safety at risk, said Art Crosby, the executive director of Lexington Fair Housing Council, a nonprofit fair housing group. Lawyers for Anderson say they were not properly notified under the 2017 law. Far from discriminating against the plaintiff, a former resident, Anderson Campus Rental Properties simply acted on rules designed to ensure the safety of the premises and the terms of the lease, said Tripp Redford, a lawyer for Anderson. So basically what they're saying, what the landlord is saying is, hey, we have no problem letting you out of the lease, following the law, but you have to notify us correctly according to the terms that were laid out in the law. And if you didn't notify us in the proper way, then you're still in violation. You know, we're not going to allow you to break your lease unless we're properly notified. And that's what the issue is here, okay? And, you know, when I get down into the article a little bit further, I'm going to let you know exactly what the notification that the state is requiring is and why this law doesn't make any sense. An EPO and what the law says. The woman involved in the lawsuit rented an apartment from Anderson Campus Rentals on Maxwellton Court near the University of Kentucky campus in 2019. The Herald Leader typically does not name victims of domestic violence and is concealing the woman's identity to protect her privacy and safety. In May 2020, Lexington police were called to the woman's apartment due to a domestic violence incident involving a man. The courts later granted the woman a protection order, prohibiting the man from contacting her, according to the court filing. The woman provided the protective order to then manager of the property, Haley Boyd, and the keys to the apartment. She needed to leave the apartment for her own safety, the court documents allege. Boyd is no longer employed by Anderson. But the woman was told that she still had to pay the remaining month's rent, and there was not an early release from the lease. She had 3 months remaining on the 1-year lease. So yeah, it seems like it's a pretty straightforward story, okay? Basically, she was involved in a domestic violence incident with a man, okay? And she took she got a protection order against that man. She took the protection order down to the property manager, gave it to the property manager and the keys, and said, hey, you know, I'm done. I've got to go. I'm not safe here anymore, okay? But, and here's the big but, right? What's missing? What's missing is basically she didn't follow the correct procedure that was laid out by the state. And I'm going to skip down a little bit into this article so that I can explain exactly what the landlord is saying about the whole situation, okay? In court documents, Anderson Community said KRS 383.300 says someone with a protection order has to provide that order to the landlord and give written notice 30 days prior to termination of the lease. The woman never gave written notice, they allege. She only gave verbal notice. Anderson also alleges KRS 383.300 is unconstitutional for multiple reasons, including a provision in the Kentucky Constitution that prohibits any law impairing the obligation of contracts. And it says here, and see, you know, that's the thing, right? You basically, you can't put a law into place that goes against the Constitution for the state of Kentucky, right? And that is a big issue right there, okay? So they need to clarify and, you know, basically let the landlord know, okay, which one of these am I supposed to follow? Does this trump the Constitution of the state of Kentucky? I mean, I don't know. You know, that's why they need this clarification. Also, what's the deal with this 30-day written notice thing, okay? If she didn't give 30-day written notice, that means that her, you know, termination of the lease isn't valid. You know, the landlord needs to know this thing, especially if they own a lot of properties, because this situation will occur again. And the state of Kentucky didn't clarify. This is my problem whenever they put all these new rules and regulations in place, that they don't clarify exactly, you know, what it means, how to implement it, and they don't look at the practical solution to the whole thing. So it also says here, right, that, let me scroll down a little bit. The man reportedly involved in the domestic violence incident was not on the lease and did not live in the apartment, Anderson Communities argued. The statute is overly broad because it permits a tenant to invalidate a lease agreement even where the non-party against whom the tenant obtained the protective order does not also reside in the leased premises, and where the tenant is not in any articulable danger from the party against whom the protective order was obtained, lawyers for Anderson Campus Rentals wrote. At the same time, the law does little to protect domestic violence victims because it does nothing to protect the tenant during the 30-day time period between the required written notice and the date on which the tenant may unilaterally treat the contract as having been terminated, Anderson Campus Rentals wrote in court documents. And those are excellent points. Okay, so the tenant has to wait 30 days, give 30-day written notice, right? Yet there's no protection for that tenant in those 30 days, and there's no clarification either. Well, this other party, this boyfriend or whatever in this situation didn't even live there. Okay, he doesn't live there. This isn't a domestic issue where, hey, we have a married couple and they live together in the place. No, this is a lady and then her boyfriend who doesn't live there, who had a domestic incident. So what would stop somebody from saying, oh, I had a domestic 10 miles over at his house, but I need to break my lease? Okay, see, that's why we need better clarification. This is why there's so many problems with this, right? And the whole thing is, all of this probably could have easily been resolved if there was just better communication between the tenant and the landlord. Okay, that is the main thing. Okay, there didn't need to be a law put into place to do this, because 99% of landlords would be understanding and would have allowed her to break the lease anyway. But then the problem is, and this is always the problem that I have, the government decides to interfere. We need new laws, new rules, new regulations, right? And then they expect us to jump through all these extra hoops to follow these laws, and it's hard to understand them. You need a lawyer to be able to understand what exactly to do, and the only way we can get it all sorted out now is by taking it to court. So yeah, this is a ridiculous situation. I don't like hearing it because, I'm not a person who sympathizes, with a person who committing domestic violence. And I do sympathize, however, though, with the victim. And I understand why she might have to leave. However, right, we need to make sure that these laws are clear. Okay, do we even need a law in place for this sort of thing? In my opinion, no. Okay. 99% of landlords are already doing the right thing and would have allowed her to break her lease with no issues. But when you put the government intervention in the middle of this whole situation, all of a sudden it becomes a mess.